road and you're out in farmland.
Who do you work for? He's talking he went to prosecutor mode.
It's throwing a, hey, look, I just committed a battery against Alexis.
Yes.
Assuming it was an unwanted touching, but
it was.
In the but so not black and white when black and white's involved.
Right.
You pull up in the black and white in a gray situation.
You love your puns over at the law firm. I do. Do you guys teach these puns as part of the process?
We could.
Yes,
we could.
I like it. Go on. I just hope our Nevada judges do not put us back together because it's almost like dad jokes. After a while,
I started it.
Yeah. Welcome. My name is Anthony Bandiero. Welcome to Our Nevada Judges. We're going to do a deep dive into qualified immunity. I think a lot of people, even if you're not in this area of the law, I think a lot of people are actually going to find this interesting. But let's start off with a quick introduction of our panel. Damien, please introduce yourself.
My name is Damien Sheets. I am the founding partner of Nevada Defense Group. We are a criminal defense firm here in the Nevada area, specifically in southern Nevada. We represent criminal defendants from everything from illegal basket weaving all the way up to murder. And we've had some very high-profile cases in that regard. And over the course of my career, our firm has represented probably over 6,000 clients across 10,000 plus cases.
Awesome. Alexis?
Hi, good afternoon. My name is Alexis Minichini. I am the Senior Criminal Associate with Nevada Defense Group. I've been with the firm for about 3 years now in September, under their wonderful supervision all these years. So, Baylie?
I'm Baylie Hellman. I am the criminal partner for Nevada Defense Group. I've been with the firm for several years now, and I run the division alongside Damien, managing Alexis and our other associates.
We have a great panel. Again, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for a firm called Blue to Gold Law Enforcement Training. All I do is train law enforcement officers around the country. I've personally trained over 35,000 police officers and about 2,000 prosecutors, defense attorneys as well, in search and seizure. And we do dive into qualified immunity. So the reason why I picked this topic is because on December 29th of 2022, the Nevada Supreme Court authored an opinion that, quite frankly, I think shocked everybody who works in law enforcement. It has to do with qualified immunity. This would, in essence, we don't have qualified immunity in Nevada. We're going to get into the detail of what that means and the repercussions. But the case is called Mack versus Williams. Can somebody give us a background of this Mack case?
Just briefly, Mack essentially was attempting to visit an inmate. I'll collectively refer to it as NDOC, but there were multiple parties with High Desert and NDOC. And in the course of her attempting this visit with the inmate, she was forced to undergo a strip search. Now,
right.
Forced, there's a little bit of debate as factually as to whether there was consent to the search. But that's for really the other courts to handle, not this Supreme Court. Ultimately, as a result of the search, even though there really wasn't anything on Miss Mack, they took her into custody, alleged that she had contraband, and she was thereafter, for lack of a better word,
banished
or stripped
right.
of her rights to basically visit anyone, and that right was indefinite. It was taken away indefinitely. She brought civil action claims.
Right.
The due process claim as to what due process she was entitled to before this right was essentially taken away from her, the court didn't really touch on that. This right was really her civil rights action under Article 1, Section 8 of our Constitution and Section 18, which both deal with different protected liberty interests. So, brief background.
Absolutely, and if you take at face value what she is alleging, it's obviously very concerning. I think also that she was there to, a little bit of backstory that I have on it, that she was there to visit her boyfriend. Her boyfriend was the one that was actually in prison, but she did bring along a friend, and I don't know the friend's name, but NDOC had a search warrant for the friend. But birds of a feather flock together, according to NDOC, so they ended up searching Mack as well. No search warrant, apparently no reasonable suspicion or probable cause that she actually had contraband, and like you said, nothing was found. And then they still banished her from the prison and stripped her of her rights to visit her boyfriend. So NDOC gets sued, of course, for the due process you mentioned, and also under the Fourth Amendment. But they also are going to make a claim under the Nevada state constitution. NDOC's defense seemed a little odd in the sense that they're like, hey, look, we will defend ourselves under the Fourth Amendment, but we want qualified immunity. But under the Nevada Constitution, there really is no right to sue us, or there's no mechanism to sue us for a civil rights violation under the Nevada Constitution, because yes, it says no search or seizure should be unreasonable and so forth, but we'll handle that under the Fourth Amendment. To me, it seems kind of a weird argument where you're saying that the Nevada Constitution has no teeth. Is that right? Is that kind of how you got the...
That's the exact conclusion that I felt as well, because essentially what they were trying to argue was that because there hasn't been specific legislation creating the right to sue, that there is no right to sue. So that would effectively mean that, the Constitution is not worthless, but it has no teeth. You can't actually enforce violations or really have any recovery for violations. It's just your right was violated and that's it. No remedy.
Incredible. And I thought that you're right. It just kind of shocked me too. Like, hey, because Nevada's Constitution is written in a very, well, I should say not the Constitution, the article or Section 18 and so forth. Is that the search and seizure provision, or is it 8? I forget.
Should be 18 is search and
18.
seizure.
Yeah, I think.
Yes.
I think 8 is due process. And so
Correct.
forth.
You're right.
Okay, so under Section 18, it really is written in a very identical manner as the federal Constitution, and we
Yes.
are the battle-born state. So when we were admitted as a state, really we pretty much abided by the federal rules, and we adopted kind of like what the feds were doing. But then you have this argument. It's empty. So, all right. So the Nevada Supreme Court says, hey, look, there is a right of action under the Nevada Constitution. That's good, but they didn't stop there. They also talked about this qualified immunity bit. What did they say about qualified immunity? Briefly, and we can go into some detail under the Nevada Constitution. Do you remember they talked about how basically there's no qualified immunity? Is that what they...
I think their ultimate decision was that qualified immunity, while it may apply in a federal situation, does not apply in the state of Nevada.
Right.
Why did they say that? Do you remember? What was it?
Off the top of my head, no. I mean, it's always been a subject of political debate between various states and where they are. In Nevada, there's been no real case law that sets forth any kind of qualified immunity, whether it be legislatively or constitutionally.
Right.
And so to create that immunity, I think given I think honestly from the political divide in the state and the direction that the state has been leaning, I think politically, I think that plays a factor in their decision.
Absolutely, right? Because at the end of the day, our judges too, I mean, many states have elected judges and they bring their own political philosophy, and that is fine. I mean, what I think about what the Fourth Amendment means may be different from what you think it means, right? Probably not very much off, but there's probably some details that we may disagree about. But I think what's interesting too is that under the U.S. Supreme Court, they have recognized a common law right for qualified immunity. And do you think that the Nevada Supreme Court could have done the same thing here? They could have said, hey, under Nevada's common law, we actually can also recognize a qualified immunity?
It's an interesting question. I mean, as we look at the way, Nevada made the determination that there is a cause of action in the first place, and they likely had an opportunity to create an immunity. I mean, there is no case law or anything to support the notion of qualified immunity. However, there was no real case law to support the cause of action in the first place.
Right.
So if there was an opportunity to do that, that was probably the opportunity for them to have done so.
Right.
And I think they chose to pass on that.
Well, I think what's interesting about, I think that specific portion of the opinion is, and I could be wrong, but they almost hint to the legislature that they should enact
Exactly.
or act in some type of a way.
Right.
So, I think for this case, maybe no qualified immunity, but if the legislature was listening and maybe paying attention, they could be in the works to maybe putting something into effect,
And I think the court takes that approach with not just here qualified immunity, but a lot of different instances where there may not be a law, because frankly, Nevada law can be kind of sparse, both in terms of case law and statute.
Right.
So I think there's a lot of opportunities where the court can say, hey, here's our decision, but hint legislature if you enacted something that would completely change the analysis.
I like that too because, I'm from Nevada, and Nevada is a small state. And like you said, it doesn't have a lot of case law, which is a good thing in some ways. And it could also be a bad thing because we look for clarification. Right. But maybe this state too, a lot of people know each other. It's not like a California where you can have a Supreme Court justice may not know their legislature as well. Right. And there's hey, we don't want to step on your toes either. I do know that there are entities out there that are trying to get qualified immunity for the state. I think at this time, though, I think a lot of viewers are going to be all right, I am a lay person. I'm not legally trained. I've heard this phrase, qualified immunity. What can you tell me, what is qualified immunity? I know there's 2 steps that the courts look at, and maybe, what those steps are, or I can also, have some notes here as well.
Well, yeah, essentially qualified immunity exists when an officer is acting in his official capacity.
And not just an officer, but other government actors.
Government actors are acting in their official capacity. It provides them an absolute protection against lawsuits for certain violations that may occur or alleged violations of constitutional rights. And in order to defeat that, there's been a pretty narrow test that exists. And the two prongs really is whether there's been a violation of a constitutional right. And that can't just be, it has to be an established right. And it has to have been declared to be established. And so that's essentially the second prong. And that's where it gets very, very narrow. There have been very few instances in case law throughout the entire United States that have established clear violations. In fact, as of just about 6 months ago, when I had done my last review of qualified immunity, there were only 4 instances that I could pick up on that were listed out as clearly established. So if you have something that we all might know as layperson is a violation of a constitutional right, if that court hasn't established it, it provides the opportunity to the defense to come forth and say, look, how's an officer going to know? How is this government actor going to know when there's been no case that shows this? And that's a product, I think, of a couple of different things. When there is one, as a party representing, if I were representing law enforcement, I think that there's a very clear violation. I'm going to do everything I can to settle the case without having a judicial finding that's going to be published to put officers on notice or government actors on notice. I'm going to do everything I can to settle that case without it becoming an established right, because in the long term, what that does, if my job is to represent government actors,
right, you end up burning other government actors because now you have this right that is they can sink their teeth into, and it makes it more easy to establish those violations.
Right, and we think of the same thing on the defense side. Anytime we're going to the Nevada Supreme Court on an appeal, we've had a fair bit of luck lately, and it's been nice. But every time we consider taking something up to the Nevada Supreme Court, there is a very real, lengthy meeting where we go through a variety of factors as to whether or not it's something we would like to take up, because there is the risk of setting forth a precedent that will then harm our clients down the line as defendants. Similarly, if you're representing government, it's the same exact situation. If you have 2 prongs, whether there's a violation, whether it's been established, and your officer in that one case, by fighting, may walk away because the court could conclude, well, this was a constitutional violation, but it was not clearly established. But we are establishing right now that it's a constitutional violation. So you're losing sight of the forest for the trees there, because now government actor A walks away, but government actors B through Z don't.
Right. Now, one thing is, the courts talk about good faith versus bad faith, and I know that from my research on this topic that the U.S. Supreme Court originally, when they established qualified immunity at the federal level, they allowed a good faith defense. In other words, they would allow officers to say, look, based on my training experience and what I know about the law, I did not intend to violate the law. They did get rid of that in a case called Fitzgerald, and they basically said that good faith is incompatible with objective reasonableness. What do you think about that? Do you think good faith, legitimate, officers, if we do believe the officer goes to court, they're being sued for violating the Constitution, and let's say that the court does find that there was a violation, but the officer had good faith. Do you think that should be a defense, or do you like the more modern standard of objective reasonableness?
I always like objectivity, but I personally think that it puts everything into a vacuum. And given your prior experience and what I've seen, I'm a former prosecutor. Prior to becoming a prosecutor, the biggest part of my undergraduate studies was the social aspects and deviance, and how that affected policing and police administration strategies. And so there was a very real tie between socioeconomic status, neighborhoods, and policing policies. And as part of those studies, I spent dozens and dozens of shifts out with the police department in Columbus, Ohio. And so to create a solely objective standard, in my opinion, it may be necessary, but I think it neglects the idea that things out there are not in a bubble, they're not in a vacuum. Situations,
not black and white.
Situations, not black and white when black and white's involved. You pull up in the black and white in a gray situation.
You love your puns over at the law firm. I do. Do you guys teach these puns as part of the process?
We could.
Yes,
we could.
I like it. Go on.
But you're in a situation there where everything turns in a minute. An officer doesn't have time to think, how should I react to this situation?
Right. They just have to respond.
He has to. I mean, he could end up dead,
Right.
or somebody else could end up dead, or somebody who's dangerous could end up getting away and pose a risk to another family. All real concerns. So I think it's a tough situation, because good faith should receive some. I would have liked to have seen a decision that maybe had this objectivity standard, but comes with an additional jury instruction that says that the jury can consider the good faith of the officer when determining the amount of damages as a mitigating factor.
Yes. So I like that because look, I am obviously pro law enforcement. I work for law enforcement, and I know that it's not perfect. If it was perfect, they wouldn't need me.
Of course.
But
or us for a lot of things.
Or you folks, right? Because there are questions in this case, and so, but you have a lot of officers that do have genuine good faith. They're trying to do the right thing, and their agency shouldn't necessarily have to spend more money than they have to resolve. But at the same time, somebody should get paid, right? If my rights were violated, I want vindication. Right. If police stop me and they stop me, they search my car illegally, they pat me down unlawfully, I want to be vindicated. However, if that happened and the officer went to court and was asked, well, why'd you do it? And the officer says, well, that's the way I do business. Well, maybe they should pay a little bit more. Then the guy says, hey, I thought this was a armed robbery suspect. I know you didn't think I had enough facts or circumstances, Your Honor, but I really thought at the time he or she was.
In other civil actions, there's a doctrine called it's the doctrine of nominal damages, where a jury can conclude, yes, you committed the tort of battery, to wit by throwing hey, look, I just committed a battery against Alexis.
Yes.
Assuming it was an unwanted touching. But
it was.
But should I pay the same as if I literally took her in the corner and beat her within an inch of her life? That's something that should be considered in an instruction. I think as a mitigating instruction would allow the jury kind of that encouragement or that opportunity to consider saying, yes, we're going to find liability and we're going to award you $1.
Well, Damien, you opened the door to another thing I want to talk to you about, and this is attorney's fees. Because when you said nominal damages, why would an attorney ever pursue that light battery by a peace officer? Let's say it's unlawful. Why would knowing that they may only get $1 for their client? There's a trick, not a trick, but there's something else going on there, and it's attorney's fees. How's that work?
But it's also the principle.
Sure, yes, it is the principle. It is.
But aside from that,
that's actually a good point.
Principle's one thing, and a finding of liability, I'm sure, will carry with it, whether or not it's $1 worth of damage or $100,000 worth of damage, will carry something inside a department. A department's not going to want to have a collection of officers that have had repeated violations. If you have a jury that concludes that Officer A has committed this tort, even if it's nominal damages 2 or 3 times, in the civil realm, you're going to be able to get into that. You're going to be able to get into the fact that the department was on notice that this person was violating.
Or they have bad training. or they have bad culture.
Right. Indicative of something else.
Okay.
It's the same as if if I'm operating a boat and I don't have the clean floors, and person A slips on my floor, and I there's $10 in damages, but then person B comes and slips on the same floor. Person B is now going to say to the jury and be able to present to the jury that this same thing happened with person A.
But see, if somebody sues you, though, right, personally on your boat, who's paying their attorney's fees? They have to pay their own attorney's fees.
Well, right, and
But that's not the case with these 1983 lawsuits, or is it?
Well, that's a great question. I don't
Do you know
answer the answer.
Know who pays the attorneys? Like if a person sues the place, let me give you a better example. This is an example where I saw this on YouTube, right? So the best examples come from YouTube. And officers were called to a residence because an Apple tag, an Apple tag, but maybe AirPods. Either way, a victim got their property stolen. They tracked down their property to a backyard.
Okay.
The cops knocked on the door, no answer. They then go into the backyard to search for the AirTag or the AirPods. Now, based on what you know about the law, does that sound lawful with those facts and only those facts? And the officers go into people's backyard to just look for AirPods?
Were there notable protections in place to delineate that there was a backyard versus a front yard?
Well, I'm just saying, like, backyards
What part of the cartilage are we on?
Well, that's exactly right. Because I have an animal
cartilage.
case where they came to the conclusion that a client of mine was not properly keeping an animal in a safe environment because he was outside in a kennel under an overhang, and they proceeded through. There was a fence around the house, but there was no gate. The gate had fallen off, so there was no gate. Animal control walked right through that open space where there would have been a gate, walked into that back door, went to trial. My client was convicted. Only on threat of appeal did the thing change, because my argument would have been that that's an illegal search of the premises because of the fact that the fence made it clear that that was a private area.
Right, it's not open for the public. So when I saw that, I got to tell you, like, even from my law enforcement perspective, I said to myself, based on what I see in that video, it's unlawful.
I didn't like it.
No, officers should not be in the backyard, right? Okay, so but that is a nominal. What happened in that case? They were in the backyard searching for the AirPods, whatever it was, for about 5 minutes. They left. Okay, but the reason we know about it is because they have cameras.
Right.
So let's imagine that occupant goes to court and sues their local police department. They want money. I got to tell you, it's definitely a George Floyd type, where they got $27 million.
Very low damages.
It's very low damages.
Maybe they stepped on your prize flowers.
I was going to say.
But that's an example of $1, I think what you said, nominal damages. But that attorney, to my understanding, is going to get paid by the government.
And I'm not sure how it works in the federal with regards to the attorney's fees. I know at the state level, there are a whole lot of options that are available to you.
That's what's interesting. Yeah, go ahead.
There's something called an offer of judgment that can be put forth. So it's a good faith offer that an attorney puts forward. It sets a dollar value on it. So if I'm representing the government and I go and I say, we will give you $1,000, just to kind of put it to bed, because the cost of litigation is going to be more than $1,000.
Yes.
Right.
And you go and you get nominal damages of $10, which is below that $1,000, and
won.
that plaintiff has rejected. While the plaintiff won the $10,000, because we'd offered $1,000 as the government, and that was rejected. Now, the plaintiff's lawyer or the plaintiff themselves are going to be on the hook for attorney's fees because of that offer of judgment. They did not meet or beat that offer of judgment.
Well, I know under the federal system, if you have a prevailing party under this 1983, which I do kind of want to make sure our viewers, there is this requirement that the defendant here, the government, is going to pay attorney's fees. And I'll just give you an example. There was a case out of the 7th Circuit where Chicago PD pulled over somebody without reasonable suspicion or probable cause. All right. I think the officer did have good faith, but the court looked at it and says, look, you should have known better. This was not a legit stop. It was a hunch at best.
Probably not a new officer.
Not a new officer.
Somebody who knows better.
Yeah.
That person was detained for about 2 minutes without justification.
Okay.
The jury gave the plaintiff $1. The attorney walked away with about $120,000 in attorney's fees because they won
they
the
were a
case.
prevailing party.
And that's,
Interestingly enough, let's flip that script to a criminal context. And the prevailing party, it's all coming back to me. There was an individual I represented in federal court who was part of a group of individuals who were accused of having essentially established shell companies in order to falsely fund businesses that didn't really exist from outside investors.
Gotcha.
So it was an investment fraud case. At the end of the day, the other parties, several of the other parties had taken a plea, and one of them decided he's going all the way. In the course of going all the way, that individual was able to show that the government, I guess, had withheld hundreds of boxes of data and not produced that to this defendant. As a result, that case was ordered dismissed by the district court here in Nevada, the Federal District of Nevada, and if I remember right, the Ninth Circuit came back and smacked the government in a very, very harsh written ruling. So the case was dismissed. Apparently, according to that defendant, the prevailing party doctrine exists as well in a criminal context, and had filed a motion to have his attorney's fees reimbursed, and it was a lot of money. It was like $1.3 million.
Right.
And the district court rejected that and indicated that because there was no conclusion to the end of the merits of the case, that they were not going to consider that to be a prevailing party situation.
Yeah, and that's unfortunate too, because that's. I mean, we could all be the brunt of this. These. Like, if we're going to trial, we're being charged. I want to know what the evidence is, right? So what I teach is, to officers, don't forget the way that you police, the way you're going to have to live in the world that you create, right? Because you're going to be retired one day and you're going to get pulled over. Do you want, Now, I just kind of want to, this qualified immunity thing can be a little bit all over the map. So let me just kind of make sure we focus for the viewers here what's kind of going on. So qualified immunity under the federal system, just like you said, Damien, it's a two-factor test. Number one is, was there even a constitutional violation? If the court does not find a constitutional violation, don't pass go and collect $200. Right. The next thing is, all right, fine, there was a violation. There was an unlawful entry into the backyard, for example. The next question is, was it clearly established? Now, clearly established, usually, is it fair to say, is from cases where the officer should know that they are messing up, right? From Nevada Supreme Court, the Ninth Circuit, or the Supreme. What about these cases? What if there's a case, let's say there's no case in Nevada or the Ninth Circuit, which for our viewers covers, our federal level, right? Our federal circuit. What if there's a case in the Third Circuit in New Jersey somewhere that says officers shall not go into backyards to look for an Apple AirTag? Does that affect me here in Nevada?
It's an argument to be made, but generally I have found, at least through my research, that anything from the Third Circuit is not a binding case. It has no effect within the Ninth Circuit of the Nevada.
Persuasive,
so it can be
at
used to
best.
persuade. Now, an attorney that's worth their weight in salt should be looking at the training materials to determine whether or not that case has ever been introduced to that officer, whether that officer has ever been trained on it, whether or not that case was taken up on cert to the Supremes, and
maybe the Supreme Court did not hear it, and that kind of endorses it opinion. Even though it is fair to say that salt is not really worth that much, so I don't know about that analogy, but I digress.
Fair enough, but I mean, people would say I'm a salty lawyer, and I think we've done okay at the firm. So
yes, another pun. I just can't.
I'm just peppering you with them, aren't I?
See, there's another one.
There was another one.
Okay, I love it actually. So the other thing we mentioned is 1983. Now I'll take this one because this is my bread and butter stuff, and I teach officers. 1983, for viewers, is a law that's been on the books since right after the Civil War. It was there to vindicate people's rights that were being violated by newly free slaves and so forth, and the South was not doing the right thing. So it allowed a private person to sue a government entity for a violation of their civil rights. Civil rights come from two sources, right? The Constitution and statutory law. A good example of statutory law would be the Civil Rights Act, like voting. Right. The ADA is also civil right, Americans with Disabilities Act, and so forth. All right.
Title VII.
Title VII.
Example,
Yeah, right,
right?
exactly. Excellent. So a person has 1983. It's a way to vindicate a civil rights violation, and then once they file that suit, it's the qualified immunity that the government is trying to establish.
Correct. Raising it as the affirmative defense to a 1983 claim.
Good.
It gives them a quick motion an early motion to dismiss that can save tens, if not hundreds of thousands
Before
of
the
dollars in
case
litigation
gets into the
costs.
merits.
Yep. Now, I want to talk to someone that's in your wheelhouse, very directly as a defense attorney. Here's what I think happens all the time. You're very competent lawyers. You get people. You have situations where your clients are let go because the cops messed up, and who knows if they're guilty or not guilty? It doesn't really matter. If the criminal goes free because the constable blundered, right? So let's say that you establish, Baylie, that an officer did an unlawful pat down. Pat downs are covered by Terry versus Ohio.
Yep.
And it says that the cop must articulate that the person is armed and dangerous. Let's say that the officer did what I call insta-pats. You've seen this every once in a while. A cop will get a person out of the car and just almost as a matter of routine, just pat them down. We know that that's not lawful. A cop would have to articulate something about armed and dangerous.
Or do what many good cops do. Do you mind if I just pat you down? Make sure it's just for my safety
right.
and yours.
Get the consent.
Get the consent.
Get the consent.
Even though I do, just so I can, my cops are watching here, I don't tell them to say, do you mind? I say, can I? Because do you mind is ambiguous, but I digress. There's mine.
I
good
have
lawyering.
generally,
That's good
I have
lawyering.
generally not, as a firm,
I have challenged the do you mind.
Do you mind? Yes, I have
have challenged the consent
I
before.
haven't, because when they say they don't mind, I don't think there's an independent fact finder in the world, but I
No, I
I
know,
agree
but
with you
I,
on
but
that.
hey, look, maybe I'll make a good defense attorney.
I've
then.
tried.
I'll just throw it out there. So I love consent, and absolutely, consent is always a way. People can always waive their rights. So
Of course.
a cop, let's say, does not get consent, which I do recommend if they don't have the articulation, and the person is patted down, and they find a meth pipe. Right? We know. I mean, cops know what a meth pipe feels like, and then they recover it. The person's charged. They go to your side of the house. You end up getting them their charges dismissed, or maybe even go to trial and find that, or not trial, but probably a motion where a suppression hearing where the judge says on the record the rights are violated.
Yep.
Now that same person would want to go sue. Hey, I want some money for this. My rights are violated, just like the judge said. Well, that's where qualified immunity comes in, right?
Yep.
Because the first part is was a person's rights violated? Well, you established
We've established,
it through,
yes.
through your legal skills. We establish it, but then we have to find that case that puts a officer on notice
To not do that.
to not do that. And I think that's where a lot of people, quite frankly, the public, who see that and say, well, why does it matter? I mean, if the judge says the rights were violated, why do we need another court to tell this officer that they should have known better? Right? I mean, it makes sense. Like, why do you get a free pass just because there's no other case out there? It's a legit.
I mean, the
argument.
common sense is, it shouldn't. Once the officer's told in the criminal context, hey, you're not supposed to do this, then there should be some sort of recovery. And I mean, I think the public policy makes sense as to why that exists because, frankly, whether it's an officer or some other government actor, a prosecutor, a judge, if they're having to second guess every single decision before they make it, that's almost an untenable situation.
Right.
But at the same time, then it precludes people who may otherwise have a right to recover from being able to recover for that violation.
Right. Now, here is the biggest conundrum. Not conundrum might be the wrong word, but paradox, maybe a better word, that this has always bothered me, even as a law enforcement attorney. What happens here is officers will make mistakes, okay? And they should have known better, maybe personally should have known better, but they violate the Constitution, and then they're given qualified immunity because there is no case on point. Let's say, actually, I'll give you a real example. So what happened was officers were chasing this person in a vehicle pursuit. They set up a tractor trailer on a blind curve, and they flooded the oncoming traffic suspect with blinding floodlights. And basically, it was a death curve, right? When you look at it objectively, like there was just no way that what they knew about this guy, his speed, where the curve was, he would have known the cops were going to step this blind curve. He basically ran into the semi and killed. He got killed. Okay. Well,
Oh my.
yeah, I mean, and it's whether it's lawful is Tennessee versus Garner and so forth. You would have to articulate that this person posed an imminent risk to them.
Right.
Like they basically could shoot them. It's the same kind of standard.
Right.
Semi truck,
Deadly
shoot
force.
them. Right.
Right.
Okay. So
Yeah.
let's say that was not really an option here. That would not have been shooting the person would not have been reasonable.
So we're going to assume that him driving at a speed fast enough that he would slam into a tractor and potentially kill somebody
They
is not
should
fear
have-
of imminent bodily harm. It's
Well, he should not have been subject to that because his crime at issue and what they knew about him, he was not necessarily going to hurt somebody else. Let's say a desolate road. It was a desolate
so
road.
this wasn't a high speed chase then?
It was a high-speed chase, but it was in the
Would-
middle of nowhere, kind of.
Not
I
where
see.
other
Well,
cars are at risk.
That would be one of the most dangerous areas if it's a one lane each way road and you're out in farmland.
Who do you work for? He's talking he went to prosecutor mode on me.
It's.
Former
Okay.
prosecutor, sometimes it comes back in.
I've played both
Man.
roles, but
Well,
I'm looking at it from that other end of this thing. And
But let's go with what the court said.
Okay.
yeah,
The court held that this was not justified use of force, that this was a death
Right.
trap, basically,
Well, right.
okay, and that it wasn't constitutional under these conditions. Qualified immunity. Because the cop did not know that this would have been prohibited. But here's what the funny thing is. Not funny thing is, that's not the word. But here's what the unfortunate thing is. That plaintiff's family, the one, of course, the estate is suing.
Right.
They don't get a penny. But they put all the work in to find that the court did find, hey, this is not clearly established law. Hey, officers in the future, don't do this.
Right.
Not like these, right? Don't do these, on these facts, you cannot do it. But you see what the problem is, how it's perverse? The first plaintiff to move forward with a constitutional violation that is not clearly established, that then establishes it, loses.
Right.
Not a penny. But the next person to come along, based on all the hard work that's already been laid by the person who did not get a penny, gets paid. How is that fair?
Well, I mean, look for example, Miranda v. Arizona, right? 1966, I think. Everybody knows what Miranda means.
Right.
And in that instance, Miranda did not have that established right in the criminal context. But every criminal defendant after him is able to use his name as a defense to a interrogation tactic.
Right.
So, I mean, it is unfortunate that you have a situation where there's a plaintiff who has been wronged and cannot recover, but it does change the law for people in the future.
But I still got to tell you, like, if I'm the plaintiff's attorney and I'm looking at this case of the death curve, and I go to my client, which would be let's say the estate, right? And I say to the family, hey, look, I got bad news for you. I mean, or good news and bad news. The good news is I really do think that your family's, rights were violated. I think that this death curve under these circumstances, this is winnable. However, I'm not taking your case. I can't take your case because I don't see where it's clearly established. And if I win, I don't get paid.
Right.
and that's the inherent risk. Is clearly established is really at the whim of the individual federal district court judge that's looking at it.
What does it
Because
mean?
What does it mean?
you have seen in the history there are several decisions where it is so narrowly construed. Let's use your case, for example. One federal judge could say, well, it's clearly established because he wasn't posing a threat to the community, and the underlying offense was not one which there was an allegation of violence or
Some imminent, immediate harm.
right.
Yeah.
And therefore, in those situations, using force or putting a series of events in motion which are likely to end up in a use of force,
Deadly force, yeah.
would be prohibited. And that's a fairly broad interpretation, and you've got to convince a federal district court judge. But then the other extreme is, well, in instances where somebody is charged with this specific offense and engaged in this specific activity, an officer learned he can't put a tractor around the corner that you can run into where Blair lights in your face.
Mm-hmm.
When are you going to find that same exact fact
You're
pattern?
not, and that's another, and that's why when people critique qualified immunity, I do understand because I do think it's unfair that the person establishes a violation and gets nothing, but the next person does. And in situations like this, it is, so. Well, Nevada, we're gonna actually roll into what Nevada. In Nevada, we don't need qualified immunity, right? So we don't need to clearly establish. But one thing I do want to talk about too is another thing that I think the viewers may be interested in is this thing called standing. In order to even bring these claims, you have to have standing. What is standing?
So essentially, standing is a basic requirement for anyone who wants to sue. But essentially, you have to allege that there's an articulable injury, that you were injured, you yourself were injured.
Basically, you have to have a cognizable injury, connection with the constitutional violation, right? So let's go. I love this actually example. You ready for this? Let's go back to our cops in the backyard example for the Okay. Let's imagine that house is rented.
Okay.
Now the occupants want to sue because they live there.
Yep.
But so does the landlord who owns the house. Does the landlord have standing?
Traditionally, no,
I would
because
agree.
the landlord doesn't have the privacy interest in the property since they're not occupying it. But I think there's situations where a landlord could assert the same claim that their rights were violated as the property owner.
Okay.
I think we need more information.
It
I think
depends.
was there damage to the property?
Oh,
Because if there
okay.
was
No,
physical
let's
damage
say,
to the property.
okay. That's very good. I like that little twist there because you're right. Let's say stepping in the tulips, right? Let's say these are
I was going to say.
right. I mean, that could be something that is. We have to look into what the real damages are. But no,
Yeah.
that's very interesting.
It depends.
Can I give you one of the funniest standing cases I've ever seen?
Yes.
A wife shot her husband. It was.
Okay.
It
We've
was.
had a few of those.
Yeah, it happens.
It happens.
Well,
He had it coming.
so the,
Chicago's coming, and I'm very excited. Okay, anyway.
so the. I love this, by the way. I think these are more fun when we kind of laugh a little bit because the law can be a little dry sometimes. But
So dry.
So
Was that really a standing case? Because it's my understanding he was lying down
Come
afterwards.
on. I knew.
I mean, I should know better at this
Yep,
time.
just walking into them.
I just hope our Nevada judges do not put us back together because it's almost like dad jokes. After a while, they
Sorry, I started it.
yeah, no, I'm actually kidding. I totally love this. So, going back to the dead husband, the cops enter the home and they enter the home lawfully. It's under emergency aid exception, fine. But they process the crime scene with no warrant and no consent by the suspect because she's taken to
Correct.
jail. So they
Off
see
the premises.
off the premise. So they have the smoking gun type stuff. They find it not in plain view, which would be like in where the cops could see it. But underneath the body and all this kind of stuff. But they process the crime scene. Well, they lose a lot of their evidence because the wife has standing. Her rights are implicated. She lives there. So when they process the crime scene, they lost a lot of the evidence. But the one thing they did not lose are the bullets in his body. And that was enough, or part of it, to convict her because they did analysis on the bullets.
But if the gun's out, how do you match the bullet to the gun?
I don't know if the gun was out. Don't quote me on that one. But let's say they had the gun lawfully.
Yeah.
Right. Because
Okay.
you would need the forensic analysis from the
Yes,
barrel.
gotta do the
So let's say we
ballistics.
have that. Right. We say we have that. But they don't lose the bullets. And that's because she has no standing about what's inside her husband's body. Kind of interesting, isn't it?
Interesting.
Oh.
Yeah. Well, he led them to the conviction.
You are good. I gotta tell you, that's a legitimate laugh right there. That's really good. Okay, so I love it. This is absolutely awesome. So I know our viewers like it too. It's always fun to have these jokes. So okay, so let's talk about damages again. Now, under the Fourth Amendment, there is no cap.
Right.
Just going
Right.
back to George Floyd, I bring this up because obviously it's a watershed event for law enforcement. It's up there with Rodney King, right?
Yeah.
The family got $27 million. Now, this was a civil rights suit under 1983. Now, they did settle, so it wasn't a jury telling them that, but it could have been a jury in the effect.
Right.
But there is no cap. But there is a cap under Nevada's constitution. So, not constitution, under Nevada law. Do you know what that number is? Do you remember what it is? It's
I
pretty
thought
low.
I thought it was 50,000 a claim. You said it's gone up to 200,000.
Yeah, it's. I think the last time it was increased was maybe 5 years ago. I could be off on that, but they've increased it to $200,000. Now, here's the deal. So, no qualified immunity under Nevada. So, if you go into my backyard and you don't have consent, you don't have exigency, some kind of emergency, which Apple AirPod would not be,
Right.
and you don't have a warrant, you're going to lose. Right? You should not be in my backyard. But we don't have to find the case to tell let's say a Henderson police officer, hey, you should have known better because we don't require that. But you're not going to get that much money from me. I'm not saying you'll get a lot of money anyway, but you only get up to $200,000. So if we have, let's say, for example, an excessive force claim.
That's exactly the situation I was thinking of as well with those medical bills.
Right.
Yeah.
So if you have let's say we have a situation, I hate to even think about that, we have a George Floyd type of situation here where an officer clearly is not only get you criminal act, but
Right.
but a constitutional violation. I mean, if the family they wouldn't do this, but only sued under the Nevada Constitution, they can only get $200,000. Now,
Yeah.
Well, and if they were to go to federal court because the case was settled, is it a clearly established constitutional violation?
what would be? I think it would be. I think under the George Floyd situation,
If it was that kind of level of egregiousness, sure.
Of course it would.
Well,
A
right,
reasonable
I mean-
officer should. I have some cases that I researched for the show where you can go outside the circuit, Ninth Circuit,
Right.
Right.
if it's something that pretty much everybody should know better.
Yeah.
And I think.
Well, right. And I think without the video, I think that's a completely different case.
Well, of course, and that's another thing actually you bring up is that, in my view, teaching law enforcement officers, since the body-worn camera has been really introduced on a mass scale, it has changed everything. Because before body cams, the situations were not just sanitized, but also, you know, kind of like the cops' word against everybody else's. Who are you going to believe, him or me? Now these videos, they show that it's not quite cut and dry, is it?
Right.
I mean, you guys are defense attorneys, you know that more than I do.
I love watching body cam. It's my
I gotta
favorite.
tell you,
Me too.
so when I worked for the city of Henderson as a prosecutor over there, they were just introducing the L3 body cam systems.
Okay.
So for our viewers, that's a camera system that was mounted to the dash of the car, and the microphone is actually mounted to the police officer. And so even if the camera would lose sight, the microphone wouldn't lose sight.
Gotcha.
I thought that was a wonderful system, and because it gave us finally a perspective on everything. From the prosecution standpoint, we knew if the case was solid, we knew if it wasn't.
Right.
We could take care of it on the front end. As the defense, it was also helpful because similarly, we could see for ourselves if we were getting an honest story from our clients,
Yep.
or if the police report was giving an honest recitation of the facts. And when the cameras first came out, quite frankly, there were considerable disparities between the video footage and both stories we would get from clients and stories that would be written by law enforcement.
Yep.
I think the cameras have been a wonderful addition. I think that the legislature has done a good job at ensuring that those should not or cannot be turned off when they're being used. You know, that was another habit that was being formed
What happened in Memphis?
by a department where they were
Right.
unhooking their microphones. They were actively talking about it. I had a sexual assault case, and I won't name the department or the client because my job is not to embarrass the department. In that particular case, the officers convened, and ultimately I learned that they were going to talk about how they had failed to collect the clothing from the sexual assault, and they had allowed her to use the bathroom after they arrived, and they had allowed her to take a shower and clean up. And they did not want that to catch on the microphones. So they had all purposefully indicated to each other to turn their mics off. They turned their mics off, however, one mic did not cut off.
Right.
And I assume that the evidence wasn't preserved in advance.
Correct.
It had to
Okay.
be sought out. But I think having those cameras is very, very helpful to provide us that unique insight. But I think many of the viewers probably would not like to hear it, but from a legal standpoint, if there's no camera there to video what's going on in the George Floyd situation or this Memphis one, which was, if there are not those cameras there to pick up on what's going on, even the officers' body cams, they weren't all that clear.
Right.
They could have easily been conveyed by the officers as he initiated that struggle. Now the officer's using language that doesn't sound particularly professional and sounds angry, but if you don't have that side view of what's going on,
The narrative
it
is
is
different.
just as likely
Well, the
that
narrative-
suspect is engaging the officer in the physical altercation.
Well, also, if you have, look, there are some officers that do commit criminal acts, and I do believe, in, you know, both of those was a. Yeah, I mean, we can debate this about the George Floyd and well, Memphis was definitely that's a
This
criminal.
was the group with the traffic stop.
Yeah, this is the one that
It's
they
the
basically
task
beat
force.
the guy to death.
Yeah,
the task
okay,
force.
and he was very close to home.
Yeah, he was.
Okay.
Yeah, it's in the
I-
neighborhood,
yeah,
and there's
I
the
remember
one
this
camera
one.
from the street light or something like that.
Yeah,
camera.
what's and it was that
Yeah.
It was actually a city cam that actually
That's what it
caught
was.
it.
The group
No,
of
these
officers?
officers are criminals,
Yeah.
right? I mean, they are committing a criminal act on scene. They're beating this guy with no justification whatsoever.
Right.
You know, he's not an imminent threat and so forth. And I guess the point is that if you already commit a criminal act, turning off the camera and changing the story is part of being a criminal. So, you know, it goes along with the MO. I do want to pick your brain. I mean, you know, again, the viewers may think this is also interesting. There's qualified immunity, and there's something called absolute immunity. Can you tell me what the difference is, or what is absolute immunity?
They're kind of basically what they sound like. So qualified immunity is going to depend on certain situations. It has to be determined to be an immunity through a qualification process, and then the absolute immunity just sort of exists blanket across the board in whatever situation it would apply.
I mean, so it applies to judges.
Right.
It
Yep,
applies to
that's what I was gonna say.
prosecutors.
Judicial immunity is
Yeah.
very much an absolute
I think that
immunity.
the judge, well, the legislature has absolute immunity. The things that they say on the floor, let's say that they engage in defamation, they cannot be sued for that defamation.
When there's recently been a Nevada Supreme Court ruling that came out that is not necessarily an absolute immunity for attorneys, but is quite close. And it pertains more to the family law side of things, where you have had lawyers that will go in and they will say anything they want about a parent, about a litigant, and quite frankly, they will just say it without a filter, even if it's not true. And somebody tried to bring that up as an issue, and the court essentially said, too bad.
Right, because you're an advocate for your client, and it's a credibility issue too. I mean, if I guess if the attorney does say something that's so absurd, the judge can be like, "Where'd you get that from?" Right?
They can, but now, I mean, the Supremes have hinted that there's virtually no liability there for the attorney. Personally, I think there should be some, or at least an attorney should be held accountable for qualifying his remarks. Or
I
remarks.
absolutely agree.
And
A qualified immunity instead of an absolute immunity.
You know,
Yeah, maybe. Yeah, there you go.
That's right.
To see you.
Love it.
Yeah. I just think about this, a judge who has absolute immunity and says, what would happen here? I'm going to sentence you, let's say it's a DUI or something like that. Let's say it's a felony with substantial bodily harm and so forth. And I'm going to, sentence you to the maximum sentence I can because I don't like you. I guess they could do that.
Judicial discretion.
I mean, obviously we'd have the Supreme Court probably overturn that, for maybe they don't like it because they can police their own, but that's absolutely, that's an example of that. So, I guess one of the last things I kind of want to talk to you about is this municipal liability. There seems to be a difference between the way courts view liability for individual officers under 1983, that statute that covers civil rights violations, and municipalities. Are you aware of what the difference is? And I think it has to do with the way the courts, in my view, not my view, it's some of my research, is that when we look at municipalities, they're not people.
Right.
No, that's, yeah.
Right? And so when we look at Section 1983, it's talking about basically people. It's government actors. They're the ones that can be sued by a plaintiff. But since a municipality, Metropolitan Police Department, is not a person, they don't. They can be sued for things that they do wrong themselves. Like it's called pattern and practice. But also, there's no qualified immunity for municipalities either, because qualified immunity also has to do with people. That's the way I understand it. I don't know if you have anything else to add to that. It gets a little complicated. That's more like the plaintiff's work, the people that are in the business. But I was curious if you had any comments on that.
It's essentially the extension of the negligent hiring and supervision doctrine at the state level. You're responsible for the acts of your employees and actors, and so is the municipality is responsible for the actions of the officers.
I got you.
Perfect example is a case while I worked for the city. The individual was sued the city for tasing him a number of times, causing him to become handicapped. And at the end of the day, the municipality settles, but the officers were under the immunity.
Was the department actually found liable in and of themselves? Did they do something wrong? Did they have a bad policy or bad training? Is that what's going on there?
Well, ultimately, the case settled prior to going to trial because the notion was that the department would be held accountable. In that particular instance, the individual was handcuffed to a hospital bed.
Yeah, I see. But yeah, I wonder how if an officer goes into my backyard, and again, we find that it's clearly established that they should not have been there, I can also sue and get money from the department, and they can be civilly liable for that, or it probably takes something more, right? They have to have an unconstitutional policy.
That's what I was gonna, because I think that's the line. It's who's making the policy. That's why we're not going to
From a
apply
plaintiff
qualified
standpoint,
immunity
you
here.
include them all.
I think you do.
From
I think
a
you do
plaintiff
include them all.
standpoint,
I
you
don't think
include the municipality, and you argue that I think you would have to. I mean, I know you're saying from a pattern and practice standpoint.
Yeah, maybe that's the way to go.
But I think you get into how many other times that's occurred through a municipal organization. You go through supervision. You get into their training if they negligently trained, and that's part of it. Negligent training is in supervision is a cause of action.
Right, but is it fair to say that if you have a one-off, rogue officer who does something that should not have been done, and the agency itself has done all the right things, they trained well, they have their policies in place. The agency themselves, they may be as a named defendant, but ultimately they're probably not going to be liable as an agency if they have done nothing to condone that.
Gosh.
I think it would depend on what the conduct done
Right.
was, because if it is completely rogue, it's almost in the
If you think
You know,
about
in
like
like a-
principal agency
Right.
I don't
law,
think it really applies too
almost
much
like in
for
a
1983
tort
though.
context, generally independent criminal acts are not,
Well,
covered.
criminal acts and so forth, but even civil rights
Yeah.
violations. I mean, we have, let's say the officer that patted me down unlawfully and found the meth pipe, for example.
Yeah.
That it's going to be very hard to sue Las Vegas Metro and say, hey, you caused this.
Right.
Unless I can say, you have training on this. You have
Yes.
training called the Instapad.
Agreed.
Hey, when you pull me out of the car, that's the issue. There's really no vicarious liability, to my understanding.
Yeah.
In 1983, you have to find. You can only yes. I think you sue everybody. That's common.
Well, and you get there in the state through the negligent hiring and supervision,
can
because
do
you
that.
get there through negligent supervision.
But that's not a civil rights violation.
Right, it's not a 1983
Right.
extension of
Yeah.
liability.
Which brings us to the last point, which is indemnification, which is kind of where you're going. Because no matter what, the agency is going to pay the bill, unless there has been bad faith. Right.
And let's be real, what it means is no matter what, the taxpayer is going to foot the bill.
That's
That's
true.
'Cause
correct.
that's the thing that frustrates, I think, most people
Yes.
when they see a $2 or $3 or $4 million settlement. They're like, good for them. I'm glad they got that. And I'm thinking,
We're paying
Jesus, I just paid I'm paying all this taxes so
Right.
that why are we not fixing this bigger problem? Because I'm sick and tired of paying taxes to have to turn around and pay settlements.
That's right, and it is a lot of money. I mean, I have I teach duty intervene around the country, and I have this chart of how much money agencies pay. Like Chicago is like $80 million a year,
Yeah.
just in civil rights violations. I mean,
Wow.
it's
Imagine how
or
many
it's-
teachers
How much
we
money
could
you could
hire with
save.
that.
Well, and that's why I like talking about, because this is a very it's a complicated subject. We kind of went into the weeds on this, and I think that's okay too. But you're right. Identification just means that the officer, as long as it's not criminal, right? There was an officer out there conducting sexual pat downs, right? He was pulling over solo drivers that are women late at night, nobody's around, and sexually assaulting them. That person, A, should did go to jail, and B, the taxpayer really, that's a criminal act. I mean, the taxpayer in that case, actually did pay money on that, because the agencies normally write checks because, even though they had nothing to do with it. But the reality is that the identification is for those people who are just doing the good faith job. Your Honor, I didn't mean to go into the backyard or offend anybody. I just thought that I could do that.
I think
and
many
pay.
times, though, you see situations where the department has received complaints about that individual officer.
Most-
Um,
yeah.
in many of those. And that's where I think the department's liability comes out. In that particular instance, if we're thinking of the same one, in that instance, there were several complaints lodged by citizens prior to.
Yes.
Yes.
And also one of the things was that he had a habit of not calling out his traffic stops. And that was a clue that, hey, why aren't you calling? Oh, I'm sorry, boss. I'm an old school guy. Sometimes we don't care. It's like, no.
Yeah, no.
And that was a clue that maybe something was going on, right?
I would want everybody to know where I am if I'm conducting a traffic stop,
But
considering
not,
it's
but not if
likely
you're
the
conducting
highest
sexual
risk.
harassment.
Right.
Not if you're engaged in criminal, right? So that should have been a clue.
Right.
Well, I got to tell you, I hope that the viewers found this information interesting. I do, as the host, I do want to kind of I like to recap stuff because there's so many ideas being thrown around. So the recap is that in Nevada, under Nevada Constitution, citizens may sue their government actors, right? Police departments, fire, etc., under the Nevada Constitution. If there is a violation, we don't care if it's clearly established or not. The agency will pay the damages up to $200,000. It's not a lot of money, but also no attorney's fees under Nevada law. That's a federal thing. What you'll probably see in reality is that people are going to sue under the Fourth Amendment to the federal Constitution and Nevada's Constitution. I call it two bites of the apple, right? See if one of them sticks. But at the same time, I think the message here too is that officers do need to get it right. They need to know what the Constitution is so that we are not, as taxpayers, paying bills and paying liability that we should be avoiding anyway. And the officers want it too, from my experience. I teach cops, again, full-time. They want to know what the law is too. They don't want to be violating people's rights.
Well, I think you had talked about the practical implications, or at least we had discussed offline about the practical implications of the Mac case. I think from a taxpayer standpoint, this actually probably poses a greater risk to the taxpayer because it incentivizes litigants to file more, I would say, piecemeal or more remedial lawsuits, or to threaten to file more remedial lawsuits. And quite frankly, even for those nominal damages situations, demand letters may end up in small settlements being paid in order to avoid the costs of the litigation that would occur. And so the question is how far that ruling stretches, how often that occurs. Now, the district attorney's office, is interesting, is one thing I didn't get to talk about, is because as we got lost in the weeds, you had mentioned established violations and getting something out, getting a court to say that they violated before you go to court. And the district attorney's office here, I think, has done a particularly good job at reading the reports and seeing something right away and electing not to prosecute.
Yes.
And by doing that, they're not only minimizing the damages, but they're also preventing that judicial finding. Or district attorneys, if you have a case where you might have a violation, the deputies have done a good job at coming and making an offer to resolve the case that a client really should consider to avoid the risk of the fight over the evidence and the loss. And that also acts almost as a protectionist situation.
I know it firsthand. That's exactly what happens. It's a win-win. The defendant, gets his charges dropped or mitigated and also, but the police officer also needs to be talked to and like, hey, look, just so you know, this was the issue with your case. Oftentimes, because this is part of my job, that I get these cases and I'm like, hey, the DA's office did not take your case. Just because of what you articulated. Now, let's look at the video. And when I look at the video, what do we find? The cop did the right thing. But they're not doing this.
Just didn't put it in correctly.
Well, and I did it,
I say that a lot.
There was a domestic battery trial one time that I did, and I was pretty tough on the officer. I was defending in this one, and I ended up with a not guilty at the end of the day. And I remember the officer came up to me and he asked me, well, what could I have done better? And I was more than willing to sit down with him and kind of go through how I thought he should have analyzed the case. And I think that most officers really go at it from that mindset versus the mindset that maybe has been conveyed to the public that all officers have. Having done it on every side. My father was a pro tem judge. I've been a prosecutor, I've been a defense attorney, and through my experience with officers in all three roles, I have found that the majority of the officers are very open to the conversation about what they can do. And quite frankly, as a defense attorney, I have received calls from, I received calls from a trooper one time. He goes, hey, I'm out here. I've got this fact situation. I'm too nervous to ask my sergeant, do you think I've got enough here, or do you think I should do something differently?
Then that's when you tell them you get some bad advice. Yeah, I don't think you have enough. I think you should let him go.
Well,
no, I think you should arrest him and give him my card.
In that situation, in that situation, I read the officer the statute, and I said, I think you might have an angle here, but it would be a lot more solid if you went at it from here. And at the end of the day, he told me based on that, he let the individual go. Because when he asked those follow-up questions that I proposed, he didn't get the answers that would have led him down the path. So,
I got to tell you too. Just we can keep on going forever. But I did meet a defense attorney one time that also gave me really did his job in the courtroom. It was a DUI, and afterwards he says, "Hey, look, he gave me his card. Says it's nothing personal. It's business. And if you ever have questions for me, I remember that to this day." Because even though I never called him, I didn't feel comfortable enough. I didn't know him well enough. But the fact that he was genuine about it too, I thought that is a great defense attorney. It's doing their job, but also willing to, be open. And it's not personal. It's business. So, anything else? Alexis, Baylie, anything else to add? No. I hope everybody enjoyed this conversation. I know I have. And again, qualified immunity. There are attorneys out there that make this their life's work. We are not practitioners in this particular area, but we want to dive in because the Nevada Supreme Court has made a very important decision, and thank you for your time.